Good afternoon, everyone, and welcome to the March 22nd, 2016 Delaware Public Service Commission meeting. Commissioner Drexler had an important appointment that's causing her to be late, so she'll be here, but she'll be just a little bit late, those of you who are missing her. And if we could, we have the reading of the meeting minutes of March 8th, 2016.
Move we adopt the minutes of March 8th, 2016 as presented.
Seconded.
Is there any discussion on the motion to approve the meeting minutes of March the 8th, 2016? Hearing none, all those in favor signify by saying aye.
Aye.
All those opposed? Anybody abstaining? The motion passes unanimously. With respect to the consent agenda, we're going to take number 3 of the consent agenda off the consent agenda and place that at the end of the regular agenda as number 4. So a few questions can be asked of staff with respect to the qualified fuel cell report. Otherwise, does anyone else have any other item on the consent agenda they wish to have put on the regular agenda? Hearing none, any motion to approve the consent agenda?
I so move.
Second.
Any discussion on the motion to approve the consent agenda, absent number 1, which has gone to number 4 in the regular agenda? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Oh, brother. I had the car key to the car, and my wife couldn't go anywhere. So no longer stuck. She's got the key. I told her it was really wonderful to come visit the meeting, but for some reason she's going to. Number 1 on the regular agenda is in the matter of the application of Delaware Power and Light Company and other entities for proposed order number 8863.
Move we adopt order number 8863 as presented.
Second.
We're going quickly.
We're going to go quickly. No one got up to
comment, perhaps?
Yeah, Mr. Dennis, please. You got me.
Questions on the
You got me
motion.
going. What's going on here?
I thought maybe you wanted to get done by 1:30, but in any event, no. If I may just have a minute, this is an order before you that memorialize your deliberations on February 23 with regard to what I will refer to as Dr. Firestone's motions. It has been circulated to all the parties, including Dr. Firestone. There have been comments received on it, and I believe that this properly reflects not only your deliberations, but also the comments from the various parties. And I would propose it for your favorable consideration. Thank you. I hope I didn't take up too much time.
No, we're not. As far as I know, we're not in any hurry. Any of the other parties here and present that wish to speak on this matter? If not, we will entertain Commissioner Conaway.
Move we adopt order number 8863 as presented.
Second.
Any discussion on the motion to approve proposed order number 8863? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Thank you, Mr. Geddes. Next on the calendar is number 2 is the matter of the application of Chesapeake Utilities Corporation. A new rate scheduled called Town of Laurel Franchise Fee Rider. And the Commission recommends amendment.
Yes, good afternoon, Commissioners. This is an application for the Commission's approval of a franchise rider. In this particular case, it's for the Town of Laurel. The proposed rate would be the franchise fee that Chesapeake will be paying to the Town of Laurel as a condition proceeding to using their public right-of-way and roads and providing gas. The proposed rate is .0181 per CCF of delivered gas. In this particular application, notice was published in both the Delaware State News and the News Journal on February 29, 2016, offering the opportunity to submit any comments from the public. To my knowledge, no one has submitted any comments one way or the other. I know this matter is not listed on the agenda as a hearing, so I talked to staff counsel the other day, and there doesn't appear to be any controversy with respect to this application. So I would think as a matter of procedure, we would request that the application and the attachments be considered Exhibit 1 in this docket, that the affidavits of publication be considered as Exhibit 2, and that the pre-file testimony of Joshua Brown, which the company has reviewed, be marked as Exhibit 3, and the company is prepared to stipulate to the admissibility of those exhibits into evidence to the extent that's necessary. The company would also note that it supports the proposed order number 8867 that is a part of the docket. I have with me Sarah Hardy, who is prepared to restate the application for the benefit of the commissions and explain why, but I'll leave that up to you. I don't think it's necessary.
The commission gets all the applications, has had the opportunity to review the application, plus the evidence you referred to. May the documents be admitted without objection?
Staff does not object to the putting those documents into the record with one change, Joshua Bowman, B-O-W-M-A-M, not Brown.
I stand corrected. Where I got Brown.
And staff agrees with council's summary of this application and is supportive and urges the commission to adopt order number 8867.
Do any commissioners have any questions of the parties?
Chair, I move that the commission adopt order number 8867 as submitted.
Second.
Before we proceed with the vote, is there anyone from the public here that wishes to be heard on this matter? Seeing no reaction, is there any further discussion on the motion to approve proposed order number 8867? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Abstentions? The motion passes unanimously. Thank you, Mr. Denman.
Thank you,
Ms. Mayorek. Mr. Bowman, thank you. Might have been Mr. Bowman's first presentation or not, if you had to do it?
Yes.
It would have been. I thought, we should have made him do it.
I know, we should.
Number 3 is in the matter of the application of Suez Water, Delaware Incorporated for a general increase in rates and for a revision to its general tariff. And that would be Mr. Collins is here. No, not Mr. Collins. It doesn't look like Mr. Collins at all. It's Larry Finicum, right?
No, sorry. It's Gary Prettyman.
Gary Prettyman. Goodness gracious, who says I wasn't 3 for 3 or 0 for 3? Mr. Prettyman, do you want to say a few words?
Sure, Mr. Commissioner. This is the interim rate increase. The company filed an increase on February 5th. So this is an interim increase reflecting $2.5 million, of which approximately $1.8 million the company was already collecting in DISC revenues. So the increase over and above what customers are already paying is about $800,000. The effective rate would go into effect on April 5th and affects all classes of customers with the exception of public and private fire protection.
Thank you, Mr. Prettyman. Ms. Mayrek?
Thank you, Mr. Chairman. Commissioners, as Mr. Prettyman has stated, what you have before you in docket number 16-0163 is order number 8861. This is an order that opens the docket to consider the rate application of Suez Water, Delaware Incorporated. This rate application was filed on February 5th, 2016, and again, this would put temporary rates into effect April 5th, 2016. This appoints a hearing examiner to conduct an evidentiary hearing. Also requires the company to publish public notice of this hearing and sets deadlines for petitions to intervene in the docket. I will note that An amended version of this order was provided to you this morning. It really just made some technical corrections to the form of public notice, which included changing a date to today's date, putting the order number in where there were placeholders, and then separating out the charge per hydrant into its own table, but there were no substantive changes to the form of notice. Tony Loper is available if there are any questions, but staff would urge the adoption of Order 8861.
Ms. Iori?
Thank you, Chair Winslow. The public advocate does not oppose the entry of the order.
Thank you, Ms. Iori. Any commissioners have any questions of Mr. Prettyman or Ms. Mayrack, Tony Loper, about this
Yes, Mr. Chair.
application?
I have a few questions, please. Mr. Prettyman, I have a summary. Actually, maybe this is for Tony Loper. I have a summary here that indicates that proposing to change the due date on its bills rendered to 20 days from the mailing date. How does that change from the current terms of payment?
The current terms are 30 days, and that particular issue will be addressed in the rate case itself. It doesn't affect the interim rates.
Okay. And one last question is, you mentioned that there is an assessment fee for fire flow tests, and I know you say you're not raising rates for public and private fire service now, but will the fire flow test penalties apply effective the 5th of April?
Again, no. Those rates will not change with April 5th. Those will be addressed in the rate case itself.
Okay. Thank you. No further questions.
Thank you, Commissioner Gray. Any further questions? May we have a motion on the proposed order?
Move we adopt order number 8861 as presented.
Is there any discussion on the motion to approve proposed order number 8861? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Thank you, Mr. Prettyman, Mr. Clarkson, and Mr. Finnegan. Thank you, Ms. Mayrack. Tony? Okay, that gets us to the hearing schedule.
Mr. Chairman, I believe we have number 3 on the consent agenda.
I'm sorry, we put that to number 4, I apologize. In that matter, Commissioner Gray has a couple of questions. If we could have someone from staff who can address those questions.
Mr. Chairman, Shauna Marshall's available for staff to answer any questions.
Thank you, Ms. Mayrack.
Thank you, Mr. Chair. I'm noting on these charges that there appears to be about a 12% net increase from once you reduce for the PJM revenues or credits. But I had a question when I look at there's a graph on attachment A that was presented for Commission's review. And in this graph, as you go across time, I'm noticing that these charges are ranging within a couple of months, more than 50% up or down. And I'm just curious, can someone briefly summarize what's driving this peak and trough? The periodic but regular increases or decreases of 50% over the course of a few months?
You have a time period in specific, or you mean
Well,
in
if you look at
general?
February, March 14, if you look at November, December 14, May, June 15, November, December 15, the fluctuation from the peak to the trough in these charges is ranging somewhat more than plus or minus 50%. And so I'm just interested to know what cost or parameters during these periods are driving that up and that down in these charges. What key parameters?
Without looking at those specific months, generally, what's going to drive the cost of these are going to be like the gas costs, the amount of that gas cost, or amount that Delaware is paying to supply to get that gas, to pay for the gas. It's also going to be the cost of the revenues are also going to drive that as well.
Okay,
So
so
it's gonna be
the
the-
revenues will bring it down and the gas costs will push it up? Is that generally what?
Well,
looking at, or-
there's a fixed part to the revenues, and then there are the PGA revenues, revenues that they get from selling energy into the market. But those fixed revenues are actually going to drive the cost as well. If there is a difference between what has been contracted to be paid to Delmarva and what they actually receive, that cost is actually paid by Delmarva's customers. So
Okay.
that is going to drive as well.
The reason I raised this is because it just seems like it's a fairly wide fluctuation if you're looking at the cost of some of the commodities that might be at play.
Those particular months that you're looking at are actually, like when you're looking at winter months, those costs are typically going to be a bit higher because the cost for energy is higher during those months, as well as during summer. You're going to see some of that as well because the cost to supply energy during the summer, that demand is higher. So that is actually going to drive this cost in the graph as well. So that's
Okay.
what you're looking at.
Okay. I don't have any further questions, Mr. Chair.
Thank you very much.
Thank you very
Commissioner
much
Gray.
for that.
Are there any other questions? Okay, may we have a motion to approve number 4 on the regular agenda, which is the matter of the qualified fuel cell provider tariff.
So moved.
I seconded.
Is there any discussion with respect to that issue? Hearing none, all those in favor, please signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion passes unanimously. Thank you. Okay, I do believe we've gotten to the hearing schedule now. And the first matter is in the provision of standard offer supply to retail consumers. Proposed order number 8854. The Commission welcomes Ms. Scott and a new Delmarva Power and Light. Oh, no, I see it. It's going to be. Thank you, Ms. Scott.
I'm here on behalf of Delmarva Power in connection with docket number 150889. And I have with me Kristen McAvoy, who is the witness in this particular matter. She could be sworn.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do. Could you please state your occupation and address for the record, please?
My current role is Senior Regulatory Affairs Coordinator of Regulatory Compliance Pricing for PHI Service Company, which is a subsidiary of Pepco Holdings, the parent company to Delmarva Power and Light Company. My office is located at 500 North Wakefield Drive in North Delaware.
And briefly describe your educational and employment background, please.
I hold a Bachelor's of Science in Finance and a Master's of Business with an accounting concentration. And I've been employed by PHI since 2006, serving in accounting and finance and regulatory functions.
And you were involved in the filing of the application in this docket in April 2015, is that correct?
Yes, I was directly involved with the preparation of the filing.
Can you briefly explain for us what the purpose of the filing is in this matter? And what it's composed of?
Sure. Delmarva Power and Light Company must submit for approval a filing for its standard offer service rates, its procurement cost adjustment rates, and reasonable allowance for retail margin. The rates include prior period true-ups for over and under recovery balances, and then sets new rates using estimates for the current period. The filing was composed of revised tariff sheets, PCA calculations, SOS rate calculations, bill impacts, RERM rate calculation, and supporting and work papers.
And as part of the process, once the application is filed, did Delmarva meet with PSD staff and the public advocate to review the documentation?
Yes, we held a technical review of the filing on June 11th.
at that point, you did a walkthrough of all the documents in the filing based on, is that correct?
Yes, I provided additional accounting support for testing and review purposes.
And did either staff or the public advocate have any issues with respect to that documentation?
Not that I'm aware of.
In this particular matter, there was an issue with the original notice requirement of publication, is that correct?
Yes.
And we came to the commission and received approval to renotice the application, is that correct?
That is true.
And was this renoticed in accordance with the amended order in this case?
Yes. Notice of this application was published on January 5th, 2016 in the News Journal, and on January 6th, 2016, the Delaware State News.
And the affidavits of publication for this notice had been filed with the Public Service Commission, is that correct?
Yes, on January 15th, 2016.
As a result of this process, has staff determined that the commission should approve the rates as final in connection with this application?
Yes.
And what would be the bill impact to customers as a result of this application?
The bill impact for a typical residential customer using 1,000 kilowatt hours per month will see a monthly decrease of approximately $2.48 per month on an average annual basis.
No further questions for this witness. She's available for cross-examination.
Are there any questions of the witness, Ms. McAvoy?
Mr. Chairman, staff has no cross-examination.
Okay. Any commissioners have any questions of Ms. McAvoy? Ms. Burek, I assume you're next?
Yes, thank you, Mr. Chairman and Commissioners. Staff has 3 witnesses to call, and if there's no objection, I would like to conduct my direct examination of all 3 at once and then proffer all 3 witnesses for cross. Their testimony is interrelated.
That's something I don't think even Jim Geddes has done.
Always
Geddes,
a first.
what she stated possible?
Anything's possible.
Well, Ms. Burek, show us how you do that.
Okay. Could I please have Pam Knotts, Tony Loper, and Shauna Marshall sworn in?
Certainly.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
My first witness is Pam Knotts, who is seated across the room, also a first for this commission, possibly.
I thought they were all working for Delmarva for some reason.
We just ran out of chairs. Well, we just ran out of chairs up here. Could you please state your name and address for the record?
My name is Pamela Knotts. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And what is your current title, and who is your employer?
I'm employed by the Delaware Public Service Commission. I am a regulatory policy administrator.
Could you please describe your role in docket number 15-0889?
I reviewed the standard offer service fixed price calculations, and I oversaw the review of the reasonable allowance for retail margin, also known as the RORM, and the procurement cost adjustment, also known as the PCA. The RORM was reviewed directly by Tony Loper, and the PCA was reviewed by Shauna Marshall, and they'll both be providing testimony today.
And can you describe the nature of this proceeding?
On April 1st, 2015, as Delmar has already stated, they filed an application for approval of standard offer service rates that include the PCA and WARM. And according to the company's worksheets, the average annual monthly bill for a residential customer using 1,000 kilowatt hours will be decreased by $2.48, or approximately 1.7%. The Commission has approved the proposed rates on a temporary basis, subject to refund, in order number 8731 on May 5th of 2015.
And was public notice properly posted in this matter?
Yes. The Commission approved amended order number 8731 on December 15th, 2015, which set the dates for publication, as Delmar was already stated, for January 5th and 6th of 2016. And The publication also said for intervention or written comments that they had to be received by January 26th of 2016.
And what newspapers was that published in?
The Delaware State News and the News Journal.
And did staff receive any petitions for intervention?
We did not.
And did staff receive any public comments or objections before the January 26, 2016 deadline?
We did not.
And could you please describe your review of the application?
We met with Delmarva for a technical review workshop pertaining to all aspects of the filing. And I personally reviewed the calculations and supporting worksheets for the standard offer service fixed price.
And can you describe how the standard offer service rates are determined?
In very simple terms, the winning bid prices and the forecast megawatt hours determine the full requirement cost by season, summer, winter, and by rate class. Full requirements cost is then divvied up by the billing determines by those rate class. And the RARM is added to that rate and grossed up for the revenue taxes. And the PCA is added to that rate to determine the full standard offer service rate.
And what were the findings of your analysis?
I did not find any errors in the calculation of the standard offer service fixed rate. I found them to be consistent with the winning bid prices that were reported by the Commission's consultant, Liberty Consulting.
And what is your recommendation with respect to the standard offer service rates in this application?
Staff respectfully recommends that the Commission approve as final the standard offer service rates, which include the RARM factor and the PCA, that went into effect on a temporary basis June 1st of 2015, with proration for the period June 1st, 2015 through May 31st, 2016.
And do you believe that this recommendation will result in rates that are just and reasonable and in the public interest?
I do.
And do you have anything to add to your testimony today?
I do not.
Now I would like to call Shauna Marshall, who has already been sworn. Could you please state your name and address for the record?
Shauna Marshall is my name. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And who is your employer and what is your position?
I'm employed by the Public Service Commission as a public utilities analyst.
And can you describe your role in this docket number 15-0889?
Yes, I reviewed the PCA procurement cost adjustment for the calculations in the work papers.
Could you please describe your review of the procurement cost adjustment?
Yes, I review all the calculations associated with the procurement cost adjustment as well as the supplemental work papers received at the workshop with Delmarva Power.
And for what period was your review?
That was for January 2014 through December 2014.
Okay. And your review is actually for a true-up of that charge, is that correct?
That's correct.
And what did you find in your analysis of these calculations?
I found the calculations to be accurate and there were no substantive errors included.
And what is your recommendation for the Commission with respect to procurement cost adjustment?
I recommend that the Commission approve the procurement cost adjustment as submitted for the period of June 1st, 2015 through May 31st, 2016.
And is it your belief that this recommendation will result in rates that are just and reasonable and in the public interest?
Yes, I do. These rates are in accordance with previous orders as well.
And does this conclude your testimony?
Yes.
All right. And now I will call Tony Loper, who has also been sworn. Could you please state your name and address for the record?
My name is Tony Loper. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And what is your title and who is your employer?
I'm employed by the Delaware Public Service Commission as a public utility analyst too.
And what was your role in docket number 15-0889?
I reviewed the supporting documents and worksheets pertaining to the reasonable allowance for retail margin, or the RARM, and the calculations for the RARM factor.
Could you please describe your review?
I attended the technical review workshop pertaining to all aspects of the filing listed by the company, but I was only responsible for the RARM review. I reviewed the worksheets pertaining to the calculations for the RARM and the supporting invoices pertaining to the incremental costs.
And could you please describe for the commission what the reasonable allowance for retail margin entails?
In simple terms, the standard offer service provider, Delmarva, is allowed to recover its incremental expenses, including any carrying costs, to provide standard offer service and hourly price service, its cash working capital, plus uncollectible expenses related to the supply and a profit margin. This charge is embedded in the supply rates for the fixed price SOS customers, and for customers meeting the eligibility requirements for hourly price service, or HPS, it's a delivery charge applied to all HPS.
And what were the findings of your analysis?
Since the RARM factor exceeded the bandwidth of plus or minus 5.25%, a new RARM factor was calculated. I did not find any errors in the calculation of the new RARM factor, which decreased by 12.5% from the current factor. The new RARM factor is 0.002254, which is a decrease of 0.000322.
And are there any other issues you'd like to address today?
Yes. The 2015 RARM includes recovery of certain franchise and state utility taxes that Delmarva is required to collect from customers and transfer to state and local taxing authorities. For a 3-year period beginning in June 1st of 2007 and ending May 31st of 2010, Delmarva did pay those taxes but failed to collect the amounts that it paid to the taxing authorities in SOS rates. These are also referred to as the uncollected amounts. According to the settlement agreement in docket 11-528 dated August 28, 2012, the total amount to be collected over 3 SOS period years without carrying costs beginning June 1st, 2012 is $3,346,205, or approximately $3.4 million. Thus, each year, the company will provide a true-up for the uncollected amounts. The total uncollected amounts, however, will not exceed the $3.4 million. To date, the amount recovered by the company is $2,902,817, and the company will continue to collect the remaining balance of $443,388 during the period for which this filing was prepared. They'll have a final true-up, which will be available in the 2016 RARM filing, expected to be filed in April of 2016.
And what is your recommendation with respect to the reasonable allowance for retail margin in this application?
Sure. I respectfully recommend that the Commission approve as final the SOS rates, which include, among other things, the RARM factor that went into effect on a temporary basis on June 1st, 2015, with proration for the period June 1, 2015 to May 31, 2016.
And do you believe that your recommendation will result in rates that are just and reasonable and in the public interest?
I do.
And do you have anything to add to your testimony today? Thank you. That concludes the presentation of staff's witnesses, and I make them available for cross-examination by Delmarva and questions from the commissioners.
Ms. Scott, do you have any questions of the staff with respect to what they've testified to, confirming that Ms. McAvoy did an exceptionally good job in her application and all her figures, asking for the rate?
No, Chair, I do not have any questions. Thank you.
Thank you, Ms. Iori.
No questions, Chair Winslow. Thank you.
Any questions from the commissioners? Well, thanks to Ms. Marshall, Ms. Loper, and Ms. Knotts. All that you got on one piece of paper, too. That was pretty good. So, anybody want to make a motion with respect to approving the proposed order?
I so move that Commission have to accept order number 8854.
Is there any discussion on the motion to approve proposed order number 8854? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion passes unanimously. Thank you, Ms. Scott, Ms. McAvoy. Okay, the next matter, excuse me, is number 2 in the matter of the provision of renewable energy portfolio standards compliance charge and credit rate to retail consumers Marvin Power and Light, Ms. Scott, please.
Thank you, Chairman Zille. Again, I have with me Ms. McAvoy as the witness on behalf of Delmarva, and she has already been sworn, so we will proceed to ask her a couple of questions about this application. Could you please indicate again what your role is for Delmarva Power?
My current role is Senior Regulatory Affairs Coordinator of Regulatory Compliance Pricing.
And again, just briefly, your educational background.
I hold a Bachelor's of Science in Finance and a Master's of Business from Rowan University.
And in connection with this particular application, were you involved in the preparation of this filing?
Yes, I was directly involved in the preparation of this filing.
And this was submitted to the Commission on April 1st, 2015, is that correct?
Yes.
And could you briefly explain the purpose of this particular filing and the components of it?
Sure. The purpose of this filing is to submit for approval a filing for Renewable Energy Portfolio Standards Compliance Charge Rate, otherwise referred to as the RPS charge rate, and for its Renewable Energy Portfolio Standard Credit Rate, otherwise known as the RPS credit rate. The RPS charge rate consists of the cost to acquire renewable energy credits, solar renewable energy credits, and their equivalents necessary to comply with the Delaware Renewable Energy Portfolio Standards Act. The cost and or benefit of the energy from contracts for renewable energy entered into the Delmarva with approval of the Commission, and the adjustment of the qualified fuel cell provider project on the RPS obligations. The RPS credit rate is for those customers who entered into an energy supply contract with an electric supplier prior to March 1st, 2012, and whose respective contracts included the cost of RPS compliance. The credit prevents such customers, in effect, from incurring the cost of the RPS charge twice, once in the RPS charge rate and a second time through the electric supplier's supply rate, which included this as an embedded rate.
And in connection with this particular filing, did Delmarva meet with staff and public advocate to review the filing and address questions?
Yes, we also held a technical review for this filing on June 11th, 2015 at Delmarva as well.
And to your knowledge, were there any issues that staff or DPA had with respect to this filing?
Not that I'm aware of.
And this particular docket also involved the issue of the need to publish because it was not published pursuant to the original order, is that correct?
Yes.
And was this then published in accordance with the amended order that was approved by the Commission?
Yes, it was published on January 5th in the News Journal and January 6th in the Delaware State News.
And affidavits of publication for those publications were filed with the Commission as well, is that correct?
Yes.
Has staff determined that the Commission should approve as final the rates that went into effect on a temporary basis on June 1st, 2015?
Yes.
And what would be the bill impact resulting from this particular filing?
The RPS charge rate bill impact for a typical residential customer using 1,000 kilowatt hours per month will see an increase of approximately 50 cents per month on an average annual basis.
That concludes the testimony of Ms. McAvoy, and she is available for cross-examination.
Any questions, Ms. Mayrack?
Mr. Chairman, staff has no questions.
Ms. Iori?
No questions.
Staff?
Thank you, Mr. Chairman. For Ms. McAvoy?
For Ms. McAvoy.
Oh, before I comment.
Ms. McAvoy, I have a question, and this related to the last item as well, but we're doing comparisons here of 1,000 kilowatt hours per month on an annual average basis for a residential customer. In actuality, does the average residential customer use 1,000 kilowatt hours a month?
It's the 1,000 kilowatt hours is the typical factor of the calculation that we use for almost all comparison purposes.
So that's the actual average.
Right, because there could be shoulder months where customers use less kilowatt hours, and then in a summer month where a residential customer would be using their air conditioner, they could be using over 1,000 kilowatt hours.
Right, but the average is 12,000 annually.
Yes.
Yeah, okay. So that's the actual average. Great, thank you.
Thank you, Mr. Chairman. Commissioners, staff calls Pamela Knotts to testify. She could please be sworn.
Please raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Would you please state your name and address for the record?
Pamela Knotts. My business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And who is your current employer?
I'm employed by the Delaware Public Service Commission as a regulatory policy administrator.
And what was your role in this docket number 15-0890?
I reviewed the worksheets and the calculations for the Renewable Energy Portfolio Standard Charge and Credits.
And could you please describe the nature of this proceeding?
Yes, as already been previously stated, on April 1st, Delmarva filed the application for the approval of the 2015 RPS rate changes, both the charge and the credit rate. And according to the company's tariff, the average annual monthly bill for a residential customer using 1,000 kilowatts would be increased by 50 cents, or 14% if there wasn't a credit impact. And the Commission has approved the proposed rates on a temporary basis with proration subject to refund in Order 8732 dated May 5th of 2015.
And did staff receive any public comments pertaining to this application?
We did not.
And could you please describe the results of your review?
As part of the RPS rate, I reviewed the recovery of the auction and administrative costs for the 2014 SREC procurement program, which included the Sustainable Energy Utility and their contract administrators' costs for the period January 2014 through December of 2014. And pursuant to Order Number 8450, which was dated September 10, 2013, in Docket 12-526, Commission approved the 2013 SREC procurement program and stated Delmarva will be required to justify any SEU-related cost above what ratepayers would have paid had Delmarva managed the solicitation itself and had Delmarva not used the SEU or the Sustainable Energy Utility as a contract intermediary. Staff continues to use this as a benchmark for cost recovery. This is to ensure that the costs related to the SEU's involvement do not exceed the costs that Delmarva would have incurred if they administer the contracts themselves. If the SEU exceeded them, Delmarva would be required to justify any incremental costs.
And what were the findings of your analysis?
I did not find any errors in the calculation of the RPS charge and the credit rates. I also reviewed the SEU and the contract administrators' costs for the 2014 SREC procurement program, and I found that the costs that for Delmarva to administer the program would result in higher costs for the ratepayers than what was paid to the SEU and its contract administrator.
And what is your recommendation with respect to the Renewable Energy Portfolio Standard rate?
Staff respectfully recommends that the Commission approve as final the RPS rates, both the charge and the credit, that went into effect on a temporary basis on June 1st, 2015, with proration for the period June 1st, 2015 through May 31st, 2016.
And what is the impact of this proposed change on the average residential customer's bill?
For a residential customer on an average annual basis, using 1,000 kilowatt hours, the increase would be approximately 50 cents.
And that's 1,000 kilowatt hours per month on average?
Yes.
And do you believe that your recommendation results in rates that are just and reasonable and in the public interest?
Yes, I do.
And do you have anything to add to your testimony? Thank you. Ms. Knotts is available for cross-examination and questions from the commissioners.
I have no cross.
Anybody worried?
I do have a question, actually. Ms. Knotts, on what did you base your conclusion that
The estimate program through the SEU was less expensive than if Delmarva was administering it.
Delmarva actually provided to us what they said would be the labor that would be involved and the charges that would be involved for them to administer the contracts. They also included in that, or they did not include in that any supplemental IT costs or anything else that would be software costs or anything else that would have to be incurred. And those costs that they stated were below what the costs of the SEU and the incline had charged.
Okay, thank you. Nothing further.
What's the dollar amount involved here? How much is the total amount of the cost that the consumers are paying? The second part of the question is has there been any thought as to why not that would be paid from the proceeds of the auction rather than be paid by the consumers?
I'm sorry, what was your second part of your question, please?
You have the auction, and why aren't the costs being paid by the revenue received on the auction rather than from the consumers?
The first question that you asked was about the total cost, and the total cost that was included in this adjustment or this filing for the administrative expenses and the procurement expenses, and subject to check, and if Delmarva wants to check, I have $21,665,568.67.
That probably answers the second question too.
As far as the procurement expenses,
well, as to who should pay it, I mean, I don't know what the proceeds are from the SEU auction, but
so far it's been treated as a cost of compliance. And back, I believe, in 2012, 2013, we had several consultants that evaluated the program. They actually came up with the costs that were being charged at that time were less. They did, I think, a comparison to 2 or 3 other jurisdictions, and they said the administrative costs and auction costs were actually less. It was in the Meister staff report as well as in New Energy Opportunity staff report that they were less than what other jurisdictions had charged. And those are charged as a cost of compliance for the RPS.
thank you very much. Anybody else have any questions of Commissioner Gray?
Yes, thank you, Mr. Chair. Ms. Knox, in your summary to the Commission, the memorandum dated February 29 on the first page, I need some clarifications when you address the increase approximately on the compliance charge of 50 cents per month for the 1,000 kilowatt hours on average as a increase of 14%. You have a footnote that says it does not include the qualified fuel cell provider monthly charge. And then in the second paragraph where you say the RPS charge consists of the adjustment of the qualified fuel cell provider project bloom on the RPS obligations, if I interpret that correctly, then you indicate that it's still only a 14% increase. So in the one case, it looks like there's a monthly charge for the qualified fuel cell that's excluded. And then it looks like RPS, by definition, has an adjustment of the qualified fuel cell provider charge included. And each is at 14% adjustment. Can you explain what my confusion is here?
Yes. Sorry, let me clarify. Perhaps I didn't state that as accurately as I should have. The offset for the fuel cell provider is included in the RPS, so it is deducted from the actual amount of renewable energy credits that they would have to procure. So that lessens the actual RPS compliance in that way. And the fuel cell charges, though, are not included in that RPS calculation. So, for instance, what Ms. Marshall just testified today, for 1,000 kilowatt hours would have equated to like $4.55 for the month that she just testified on. That would not be included in this RPS. It's a separate charge. So even though the offset
is taken out of the RPS compliance for the number of RECs that they have to procure. I just wanted to make sure that it was not stated that the fuel cell charge itself would be included in there.
Okay, so this statement where you say the RPS charge consists of, and you say item 3, the adjustment of the qualified fuel cell provider project on RPS obligations. That's the part for me which is still not specifically clear.
That's the SREX, right?
And I'm sorry, is that
so,
paragraph 2?
So paragraph 2, if I read from the first sentence, and I'm just extracting, the RPS charge consists of, and you have 1, 2, and then you have item 3. And item 3 says the adjustment of qualified fuel cell provider. I'm looking for some specific clarity on that item 3.
Yeah, that should have been stated more accurately, is the offset is included in the RPS.
Offset, for me, by definition, means?
The offset, the bloom equates to so many RECs or SRECs by statute.
Okay.
So that offset to the RPS compliance, the number of RECs that Delmarva would have to procure is actually offset by the bloom generation.
Okay, I understand now. So there is a reconciliation of that in the overall, before the increase applies to the ratepayer.
Yes, that has already taken place. That, for instance, just in simple numbers, if Delmarva had to procure 500,000 RECs, they took the bloom, the fuel cell adjustment off of that. Let's just say it was 200, they'd only have to procure 300,000 RECs.
Okay.
That adjustment is subtracted from the original quantity.
Okay.
I'm sorry, I didn't mean that to be...
That's okay, and I know it's complicated, but that gives me much more clarity. I
Okay.
appreciate that very much. No further questions, Mr. Chairman.
Any other questions?
Motion to approve proposed order number 8864.
Second.
Is there any discussion on the motion to approve proposed order number 8864? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion passes unanimously. Thank you, everyone. Number 3 is in the matter of Delmarva Power Lights Company's annual gas cost rate filing. Once again, we welcome Ms. Scott.
Thank you, Chairman. So we are here in connection with the annual gas cost rate application. In this particular matter, the parties have reached a settlement in this docket. And we have, as a preliminary matter, we have prepared an exhibit log that indicates all the exhibits in this application. And I approach.
So, yes, ma'am.
So Chair Winslow and members of the commission, the exhibit law is all the exhibits that have been filed in connection with this application, but for the settlement agreement. The parties stipulate all the documents that appear on the exhibit log and ask that they be admitted into evidence for the record.
They're admitted as evidence on the record.
I have with me, since we've reached a settlement, each of the parties are going to have a witness that will specifically address the settlement agreement. So I have with me, on behalf of Delmarva Power, Mr. Bob Gromeyer, and I ask that he be sworn.
Please raise your right hand. Do you swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Bromeyer, by whom are you employed?
I'm employed by Delmarva Power.
And what is it that you do for Delmarva Power?
I'm the manager of gas operations.
What does that mean in terms of your duties and responsibilities?
My duties include overall responsibility for our regulator and gate stations, our LNG plant, our gas control center, our pipeline supplier relationships, and various other regulatory and business matters.
And how long have you held this position?
I've held this position for 6 years.
And how long have you been with Delmarva Power?
34 years with the company.
In connection with the proposed settlement in this docket, were you involved in the filing of the application for the GCR, along with the preparation of testimony of witnesses and the settlement discussions?
Yes, I was.
Outline for the commission the specific terms of the proposed settlement agreement that the parties have reached in this matter?
I will. Okay, in this settlement, the parties have agreed to implement the rates as filed, which will result in a reduction for customers for residential gas, residential space heating, and gas lighting customers. They'll receive a 26.3% decrease in the level of the gas cost rate. The effect on a residential space heating customer's winter bill of 120 CCF will be a 12.9% decrease in the total bill, or $16.92. For customers served under our MVG and LVG classifications, they'll experience decreases ranging from 0.8 to 12% on their winter bills, depending on their usage. For customers in our general gas, our small commercial class, they'll experience decreases ranging from 5.9% to 16.3%. The next settlement item is that we will continue to execute the commission-prescribed hedge program, and we'll continue to conduct quarterly hedge meetings with staff and DTA. Next item is pursuant to the terms of the settlement agreement in docket 140295F. The parties have developed a streamlined process for these GCR filings, and that has been implemented with this docket. Next item was an open issue pertaining to lost and unaccounted for gas, first identified in docket 12-419F. Delmarva submitted a technical report of its findings to the PSC and staff on April 30th, 2015. Consistent with these findings, Delmarva reduced the deferred fuel balance in the GCR by $2 million. That was previously under 12-419. In this docket, we've credited an additional $2.34 million to the GCR, and also an additional increment of $418,000 in interest, bringing the total in this docket to a credit of $2.758 million. And as a result, the GCR has been reimbursed for the total amount determined to be due as a result of the lost and unaccounted for gas matter. The next item we had was we agreed that we would eliminate the separate allocation of demand costs to RG, GG, and MVG customers per the requirements of the settlement we reached in docket 14-0295F. The next item was in our upcoming 2016-2017 GCR application, we've agreed to present and for the parties to address whether additional or modified measures are needed to protect GCR customers from stranded costs associated with customer migration from sales to transportation service. We will also address a staff DPA recommendation with respect to a tariff change to Leaf 59, Section U. Next item we agreed to is that until the Commission issues an order rendering its findings in the 2016-17 GCR application for purposes of determining whether there is sufficient natural gas supply for in the company's portfolio for transportation customers who might desire to return to sales service, the company will allow people to return to sales service if we maintain a reserve margin at 2% or greater. Next item is also something that will be in effect until an order is issued in the 2016-17 proceeding. The company will not contract for any additional upstream pipeline capacity unless staff and DPA agree that the acquisition of additional capacity is reasonable. In addition, the company has agreed that in the decision-making process for any future increases in pipeline firm capacity, they will continue to perform a solicitation and evaluation of city gate delivered peaking services as an alternative.
Those were all the substantive provisions contained in the proposed settlement agreement, is that correct?
That's correct.
And the settlement agreement has been signed by the parties in this proceeding, is that correct?
That's correct.
This is the document.
It is.
May I approach, Chairman?
Yes.
I apologize, I only have one version of the fully signed settlement agreement. But that is the agreement that all the parties have signed in this matter. That Mr. Bromeyer just testified to. In your opinion, Mr. Bromeyer, will the implementation of the proposed settlement agreement provide for just and reasonable rates for customers, and is it in the public interest?
Yes.
And why is that?
3 reasons. I think you'll note the significant decrease in costs for customers. Second, it avoids the costs and use of resources associated with litigation. And third, it amicably resolves several issues raised by staff and DPA in the proceeding.
That concludes Mr. Bromeyer's testimony. He is available for cross, and I would ask that the settlement agreement be included in the record for this proceeding.
I note that there are 2 signature spots for Delmarva Power and Light, one of which has been executed and one of which is
It's
not.
probably because there's
Extra page.
There's an extra page. We didn't all do this in the same room, so there was.
No, I understand. And this is to the exhibit, as an exhibit, so it's entered without objection, I assume, since everybody's, it's a settlement agreement.
That
Yes,
would,
Without objection, it's Exhibit 12, Mr.
that
Chairman.
would be exhibit 12.
Exhibit 12. So admitted.
Mr. Bromeyer is available for cross-examination.
Ms. Mayrek, any cross?
No cross-examination from staff, Mr.
Ms.
Chairman.
Iori?
No questions.
Ms. Mayrek?
Thank you, Mr. Chairman. Staff calls just one witness for this docket, Mr. Jason Smith. If he could please be sworn.
Do you swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Could you please state your full name and business address for the record?
My name is Jason Smith, and my business address is 861 Silver Lake Boulevard, Suite 100, Dover, Delaware.
And who is your current employer?
I'm employed by the Public Service Commission.
And what is your title?
I'm a Public Utilities Analyst 3.
And could you please describe your role in this proceeding?
Sure. I was assigned as an analyst to support Ms. Malika Davis, the case manager in this proceeding. I've been actively monitoring this case and have been reviewing all of the correspondence, including the company's application, the discovery, and testimony since it was filed in August of 2015.
And are you familiar with the testimony of Ms. Malika Davis, which was filed on behalf of the Commission staff in this docket on January 8th, 2016, and entered into evidence today as Exhibit 8?
Yes, I am. Ms. Davis's testimony reviewed Delmarva's proposed rate schedule changes, adherence to prior settlement agreements, and the company's forecasted gas sales and supply costs.
All right. And do you have any changes, modifications, or corrections to make to that testimony?
No, I have no changes to make.
And do you adopt Ms. Davis's pre-filed testimony?
Yes, I do.
Did staff retain any experts to review this matter?
Yes, Mr. Jerome D. Mirzwa of Exeter Associates assisted in the review of Delmarva's application for both staff and the Division of the Public Advocate.
And are you familiar with Mr. Mirzwa's testimony, which was filed on behalf of Commission staff on January 8th, 2016, and also entered into evidence today as Exhibit 9?
Yes, I am. Mr. Mirzwa's testimony focused primarily on the acquisition of additional capacity and potential for existing transportation customers to return to sales service.
And do you have any changes, modifications, or corrections to make to that testimony to ensure it's accurate as of today's date?
No, I have no changes to make.
And do you adopt Mr. Mears's testimony?
Yes, I do.
Could you please address some of the issues in this application which concern staff?
Sure. Staff really didn't take any issues with the company's proposed rate changes in the application or the proposed tariff changes. Our only concern really was the issue raised for the potential of having stranded costs due to customer migration and capacity acquisitions. Because of the methodology that was approved in another Delmarva gas docket, which was 15-0671, Delmarva felt that some transportation customers may decide that sales service is a better option for them. Staff didn't necessarily agree that the customer migration may happen, so that the parties best agreed that it was best to review this in the context with the company's next GCR application filing for the 2016-2017 year. The company did address this issue to staff satisfaction, which to be noted in the settlement agreement in paragraph 13. Other than that issue, there really were no substantial or contested issues that needed to be addressed in this particular docket.
And do you believe that the proposed settlement agreement will result in just and reasonable rates and is in the public interest?
Yes, I do.
And could you please explain why you reached that conclusion?
Sure. There's a few reasons why I can reach that conclusion. The first is being that I found that the GCR rates were calculated correctly and in accordance with the company's tariff. Second, since Delmarva addressed staff's main issue in this docket to our satisfaction, this really leaves no remaining substantial issues that need to be addressed. And lastly, as with most settlement agreements, they are reached despite differing viewpoints of all of the parties involved. So therefore, the interests of the parties and those in the public, I think, are balanced as a result of this agreement. It's also in the public interest to avoid the time and costs associated with additional litigation on this matter. So therefore, I would respectfully recommend to the Commission to approve this settlement agreement that's reached in this docket.
And do you have anything to add to your testimony today?
No, I do not.
Thank you. Mr. Smith is available for cross-examination and for questions from the commissioners.
Any questions of Mr. Smith? Okay, commissioners have any questions of Mr. Smith? I assume there's no further comments with respect to the settlement agreement. Everybody agrees to the settlement agreement?
DPI has a witness, gentleman's left. Again.
We would love to hear from her.
I do. Swear that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Will you identify yourself for the record?
My name is Andrea Moucher. I'm with the Division of the Public Advocate.
And what is your position with the DPI?
I'm a public utilities analyst.
And what are your duties and responsibilities in that position?
Primarily, I act as case manager for all dockets opened by the Public Service Commission and in which the DPA has intervened. In that role, I'm responsible for analysis of utility filings and discovery, retention and supervision of expert witnesses, and participation in development of positions taken by the public advocate.
And as part of your duties and responsibilities, did you review the application of Delmarva Power and Light Company for a change in its GCR rates?
Yes.
Did the public advocate participate in retaining Jerome Mearsla to review the application on behalf of staff and the public advocate?
Yes.
Did you review Mr. Mearsla's testimony before it was filed?
Yes.
And have you reviewed it since it was filed?
Yes, I reviewed it in preparation for this hearing.
Do you have any changes or corrections to make to that testimony at this time?
No, I do not.
Do you accept or adopt Mr. Mearsla's testimony as your own on behalf of the public advocate?
Yes.
As the DPA's witness and having been present during this examination, you're aware that the parties have reached a settlement in this case, correct?
Yes.
Do you believe that the proposed settlement results in just and reasonable rates for residential and small commercial customers and is in the public interest?
Yes, I do.
Why do you believe that?
First, the settlement recommends approval of Delmarva's proposed GCR rates. Pursuant to statute, the GCR is a pass-through of the natural gas commodity costs Delmarva incurs to provide service to its customers. The calculations are either correct or they are not. And in this case, the rates have been calculated correctly and in accordance with the company's tariff. Therefore, there's no reason to expend additional resources on litigation in this matter. Second, the company has credited the current GCR filing
$2,758,730, which includes interest for lost and unaccounted for gas associated with serving a large volume gas customer. This issue was first identified in Delmarva's 2012 GCR filing, when $2 million was credited to firm customers while the issue was investigated. An April 2015 report filed by the company detailed the results of the investigation and the balance to be credited in this GCR. With this credit, the GCR has now been reimbursed for the total amount determined to be due, and the issue is resolved.
Has the company agreed to any changes in its next GCR filing?
Yes, Delmarva has agreed to examine whether additional or modified measures are needed to protect GCR customers from stranded costs associated with customer migration from sales to transportation service. This includes consideration of the staff DPA proposal for changes to the transition charge language in the company's current gas tariff.
Are there other issues addressed in the settlement agreement that you wish to discuss?
Yes, as raised by Mr. Mirzwa's testimony, the staff and DPA have concerns with Delmarva's acquisition of additional upstream capacity to serve transportation customers that may desire to return to firm sales. Pursuant to the settlement agreement, these issues will be addressed by the company in its 2016-2017 GCR application. However, until the Commission reviews the matter and enters a final order in that future docket, the company has agreed it will not contract for additional upstream pipeline capacity or participate in a bidding open season for such long-term capacity unless staff and DPA agree that the acquisition of additional capacity is reasonable. Further, the parties have agreed a reduction in the company's projected capacity reserve margin to 2% and less would constitute a finding that inadequate capacity is available to permit the return of non-core or transportation service customers to sales service. In conclusion, I believe the settlement agreement in this case results in just and reasonable rates for residential and small commercial customers and adequately resolves the concerns raised by the parties. Since it is unlikely the Commission would reach a substantially different decision, additional litigation in the matter would be a waste of time, effort, and dollars that would ultimately be paid by customers. For these reasons, I urge the Commission approve the proposed settlement agreement.
Thank you, Ms. Melcher. Ms. Melcher is available for cross-examination and any questions the Commission may have.
Thank you, thank you, Ms. Iwery. Do any of the parties have any questions of Ms. Melcher?
No questions from staff.
No questions.
Any of the commissioners have any questions of Ms. Melcher? And that's it, right, Ms. Iwery?
That is it.
Okay.
Mr. Chairman, I would just note that we do not have a proposed order before you today due to the settlement being reached late yesterday. But what the parties are asking for is that the Commission approve the settlement agreement between the parties, approve the rates, which went temporarily into effect on November 1st, 2015, as final, and approve those rates as filed, and then we would have an order memorializing the Commission's decision if it chooses to make that decision at the next meeting.
Thank you, Ms. Mayrek. Would anyone care to make a motion to fulfill the request that Ms. Mayrek has made on behalf of all the parties?
So moved.
I second it.
Is there any discussion with respect to the settlement agreement between the parties regarding the annual gas cost rate and the other items referred to? No questions? All in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? And the motion passes unanimously. Thank you, everyone. Is there anyone here from the public that wishes to make any comment to the Public Service Commission? I don't see anyone approaching. And next is our line director and his comments.
Chairman Winslow, Commissioners, thank you for the opportunity to share a little bit more information with the Commission. I'm glad that I've not been sworn, so everybody's been sworn in this place but me, so I will continue to lie as usual.
We haven't been sworn at either. So.
If most of you are probably aware that the Commission received a request to support a NARUC ex parte communications to the FCC commissioners on the state eligible telecommunication carrier role. I asked Ms. McDowell if she would share her thoughts on that with the commission in case there is any action the commission would like to take on this issue.
Good morning, or good afternoon,
Good
Commissioners.
afternoon.
I presented you with a memo, and you asked me for my guidance on whether you could support the comments that Naybrook would like to file with the FCC. And the issues involved are very minimal here in our state. We only have one, what they call eligible telecommunications carrier that's been certified. Now, that doesn't mean that there aren't others out there in our state. There's wireless carriers that have sought certification from the FCC, and probably other carriers who want to do it on a national level. We did not create a state universal service fund because we had a 97% take back in 1996 by all citizens here in Delaware for telephone service. And the rate that Verizon charged was very low. It was $9.40 a month. That only gave you dial tone line and access to 911, which was what the lifeline requirement was at that time. Now you can have whatever telephone services you want, but you only get $9.25 presently towards your telephone service. So if you're low income, that's the subsidy that you receive. Plus, in some states where they did create the State Universal Service Fund, they get whatever they've created as a additional monies off your bill. But it's very low key here. We've never received a complaint. We do get the activities of Verizon every year, which Mr. Howitt writes up a letter for you and submits it to the FCC on their activities. So it says how many people participate in the program. Now, nationally, they've had issues with the Universal Service Fund in such areas as people would sign up for different carriers. You're only allowed one take, so they would get an approval from their wireline, and then they would get cell phone approval. So I think they put enough regulations and criteria on that they pretty well nipped that. But the states get reports from the companies they certify. So if the FCC takes away the certification from the states, the ones that have a state universal service fund feel that they will not get adequate reporting to make sure there's no fraud and abuse going on. So I think that you could support the comments that they would like to file. It's not as big an issue, like I said, in our state, but you could support your other state commissioners out there.
Thank you, Ms. McDowell. I think that's exactly the reason why I wanted to see this on the calendar. It's not really important to us, but at least we'll hopefully have a perception from other states that we're supportive of them when they have some good issues. The only problem I have is that sometimes it's very difficult to get those other states to be supportive of us, but we'll be kind. I think we should be kind in this situation. I would like to hear from Commissioner Gray, who's really on top of this issue.
Thank you, Mr. Chair. Thank you, Connie. Yes, this came up in telecommunications committee meeting at the National Association of Regulatory Utility Commissioners. And I think they had, as of last night, 25 different state commissioners had signed on to notify the FCC that there are concerns about taking this authority or encroaching on the state's authorities in this regard. And I'm not specifically aware whether if FCC takes this authority from the states, in the future there are companies that will apply to the FCC to operate here, and we're completely out of the loop because they never applied here. We didn't give them the authority to operate here. But the FCC has given them an allowance that then we have to in some ways track or be concerned about. So my recommendation, of course, to my fellow commissioners would be, it seems like a fairly neutral impact on us, but I think that if it has no downside consequence, I would recommend that the commissioners agree to issue a letter of support from the Delaware Commission on behalf of the rest of the states to the FCC accordingly.
Mr. Howard, any comment?
After you have decided whether you would like to support that document to the FCC, I would like to make just a short comment about how we handle some of these issues when they come about.
Okay, thank you.
You should vote on it with a you support.
Yeah, well, I plan on doing that. Any questions? Anybody have a question? Commissioner Gray, you want to make a motion?
I hereby move that the Delaware Commission issue a letter of support in alignment with the NARUC Telecommunications Commission, informing the FCC with regard to the ETC matter which we've just discussed.
I second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed or any abstentions? The motion passes unanimously. Mr. Howard.
Thank you, Chairman Winslow, Commissioners. You are undoubtedly in positions where you're going to be lobbied to join in with NARUC or other agencies that would like the Commission's support. And it makes it very difficult in Delaware to do that by virtue of the fact that, well, number one, you're part-time commissioners and you're not in the office every day working 8 hours every day or 10 hours, as the case may be. And secondly, we have this wonderful thing in Delaware called the open meeting law, which requires that a lot of our actions be taken in a public open meeting forum. I guess for benefit at least of the new commissioners, as you are lobbied by individuals who would request that the commission support certain efforts, I would suggest that you think about the fact that we can have a meeting of the commission at about any time we would like to have a meeting of the commission, subject to 7-day notice of the agenda. So if in fact something really important comes up that we have to get on the table, we can have the secretary set up a meeting, a special meeting for that, and we can have the meeting in an open public forum with an agenda out there that identifies the item to be discussed as long as it's done 7 days in advance of the meeting. This is one of the issues that we have in Delaware. It obviously has some good things going for it. It has some downsides going for it in that we're not nearly as responsive as some other commissions may be. For instance, the Maryland Commission routinely makes decisions behind closed doors and then writes the order and sends it to all the parties. And so they don't have the same constraints that this commission has with respect to Delaware statute. So just to give you some suggestions about future involvement on commission decisions would be, let us know if something's really important and we can schedule a meeting and put it on the agenda and make it happen. The other possibilities are you as an individual could perhaps sign if that was what was being requested. Or the other thing is that the staff could take the request under advisement, put our heads together, and the staff could actually go ahead and sign support on a particular issue. That's kind of, unless Ms. Mayrack or Mr. Geddes has any other advice and counsel with respect to this issue, I just wanted to be fairly clear that I don't know how else to do that with Delaware's open meeting laws.
The only caution I would say is with respect to individual commissioners personally signing on something like similar to this is that it's very difficult to distinguish between you as an individual and you as an individual commissioner. I mean, it's a very difficult situation. I would not recommend anybody signing on to anything unless this whole commission approved the signing, so to speak, or the support for that particular issue.
I would tend to agree with the chair, and for that reason, when this came my way, I was very reluctant as an individual to put my signature over my title until at least I brought this before my fellow commissioners.
And also, we got some good advice from our lawyer, Ms. Mayrek. Okay, next item, Mr. Howitt, is I see some prominent members of the water community in the audience. I assume they're going to be interested in the next item.
Chairman Winslow, we have started a process to examine the contaminants issue with respect to water, and Mr. Nielsen would probably like to bring you at least up to speed on what we've been doing and the direction that we've been taking with respect to that.
Thank you, Mr. Howitt.
Good afternoon. As you know, the city of Flint, Michigan has been in the news for water quality being provided in the city to the city residents. According to news reports, the problem in Flint began when the city's water source was switched from a feed from Lake Huron, which they were paying the city of Detroit for, to the Flint River. Apparently, the water from the river was acidic. It caused lead in the water system components and or customer piping to leach into the water. The source of the lead was not from the water itself, but was from the deterioration of the system components caused by the acidity of the water. In addition, the water became orange in color, indicating iron in the water. Again, the iron was caused by the corrosion and deterioration of the water system components and customer piping. Testing of pH of the water and testing for lead and copper, as required by EPA, should have discovered the issue before it became the issue that it has become. In Delaware, the Commission and other state agencies have received questions concerning the water quality and specifically the water utilities compliance with EPA and safe drinking water lead requirements. The Department of Health and Social Services, Division of Public Health, Office of Drinking Water is the primary agency in charge of water quality in the state. The Office of Drinking Water has jurisdiction over all water providers in the state and is the state agency that tests or reviews test results for those water providers. As you know, the Commission has jurisdiction over privately owned water providers within the state. In order to understand how our regulated water providers are complying with the EPA lead rules, the Commission sent a series of questions to all of our Class A water providers. Those are the ones that have $1 million in revenues or more each year. In addition, we expanded the questions to include compliance with the copper requirements. As all of the Class A water providers have responded, as you can see all this paperwork I have, each of the providers have had their water tested and continued to test their water for lead and copper. Companies have installed treatment when necessary to adjust the pH of the water to keep it from being corrosive, and in some instances they have installed treatment that coats the pipe in order to protect it from corrosion. Although not required, some of the utilities have replaced lead containing piping when appropriate and cost effective. However, even if the utility systems and plant were replaced with lead and copper free materials, customer piping may still contain lead and copper. Therefore, the utilities continue to monitor their water quality as required by the EPA and Office of Drinking Water. As needed, adjustments are made and accelerated monitoring is instituted as they find problems or things come up. As discussed, the Office of Drinking Water is the primary water quality agency, but the Commission's jurisdiction includes ensuring that its regulated water utilities provide safe, adequate, and reliable water to their customers. Staff has prepared a report in which we discuss the issues experienced in Flint and how the agencies and water providers within the state of Delaware monitor and ensure compliance with the EPA lead and copper rules. And that report is being reviewed at this point. So.
Thank you, Mr. Nielsen. I just wanted to make sure the Commission was aware that we were reviewing the circumstances, and in particular as they pertain to Delaware, and that we will be providing you with a white paper report on our findings and recommendations with respect to water contaminants, particularly in the Delaware area.
Thank you, Mr. Howard. Thank you, Kevin. Is there anyone here who wants to speak on the water lead issue? I see Dave Spade from Artesians here. I see. I don't know if anybody, I guess we got Mr. Hubbard's here. Anybody want to speak? You don't have to, obviously.
Chair, I have a comment about it, if you don't mind. So I attended a city council committee hearing in Wilmington, the largest city, and they are also in discussions about the quality of their water as well. And I learned a few things about the water and its distribution, and that is that, you know, the water companies can fix everything, but the service lines that are coming from the distribution at the street or the copper wells that are inside the residential properties are a fairly decent source of the lead that can get into the water supply. But they're testing. They've got a couple of criteria, I guess, from the EPA where they go out and they test actually at the source where the water is dispensed. And they have a couple of programs where they considering meter replacement and rebates for replacing service pipes that might in fact be lead-based or pipes inside of old residences. So it's an important issue. I have one question. When you said the Class A water providers that we regulate,
yes.
What percent of the customers do they cover out of the group that we actually are regulating? Is it like 90%, 100, 95, 80, 70%?
I don't have an exact number, but I would think looking at the other ones that are on here, that it's probably over 90, definitely over 90%.
Thank you very much. No further.
Thank you. Thank you, Kevin. One last item on here. Ms. McDowell would like to update the commission on the telecommunications relay service issues that have been going on. Ms. McDowell is our advisory representative to the Telecommunications Advisory Committee. So, Ms. McDowell?
Yes, I just wanted, this is just FYI, in case you get any questions from legislators or someone in your community. The telecommunications relay service is under Title 26 of the Delaware Code. We used to regulate it back in the day, when that cost was embedded in dial tone rates. And in fact, I was the staff member who did that case. And it was like 15 cents for each dial tone line. Since that time, in 2009, they set up an advisory committee. And in the law, it says specifically who the members are required to attend. We're not required. We just act as an advisory. And they do ask us questions from time to time about whether different telecom companies are certified in their state so that they can bid on the contract. But the contracts are all under the Department of Information Technologies, and the Homeland Security and Department of Finance both look at the funding. So we're pretty much out of the picture. But they did want to change the advisory committee because there's two associations that do not attend and have not for years, but they were required. They did try to contact them and have been unable to even get somebody to call them back or write to them or anything. There's also, since 2009, there's a couple other councils that have interest in the telecommunications relay service, and they would like to add them on. So they're going to have more control with this legislation on picking additional members if they find that others need to be added. So I did want to make you aware that they are going to introduce this legislation this fiscal year. Anybody have any questions?
Thank you very much.
Thank you, Ms. McDowell. Our next meeting is on Tuesday, April the 5th, starting again at 1 o'clock in the afternoon. Hope everybody has a happy spring.
Happy Easter.
Which spring? Is it the one that is
Thank you all very much. The meeting is adjourned.